Hi students, so we're going to continue on the next element of contract, which is capacity to contract. So in order to form a valid and binding contract, the contracting parties must have the capacity to enter into a contract. Each party must be competent to make a contract. Okay. Capacity di sini bermaksud kelayakan untuk membuat sesuatu kontrak. Section 10, subsection 1 provides that all agreements are contract if they are made by parties competent to the contract. What is the definition of competent? Competent adalah layak dari sudut undang-undang. Who has the capacity? Section 11 of the Act states that every person is competent to the contract who is of the age of majority, which is above 18 years old, and of sound mind, can think rationally when the contract is entered, and is not disqualified from contracting. Okay, for example, a bankrupt person or insolvent is disqualified from contracting. Contracts by minor. Who is a minor? Okay, Section 1 of the Act of Majority Act 1971, it states that a person attains the age of majority at 18. Therefore, a minor is anyone who is below 18. Okay. The effect of contract entered by minors. The general rule is that a contract by minor is void. Because why? Minors are not competent to the contract. We can refer to Section 10, subsection 1, as we have discussed earlier, and also Section 11. Therefore, a minor cannot be sued upon a contract because a minor also cannot enforce the contract. There are two cases here. So, let us see on the case of Mohari Bibi against Dormada Schools. Okay, this is an old case, a precedent case. In this case, the appellant lent the respondent, a minor, the sum of 20,000 rupees. Okay, this is the appellant and this is the respondent. Okay, the appellant always comes first. So the loan was secured by way of mortgage on some houses belonging to the respondent. The appellant knew that the respondent was a minor. Later, the respondent brought an action for declaration that the agreement was void because he is still a minor and lack of capacity. It was held that the agreement is void and therefore is not binding on the respondent. So, what happened in this case was that the appellant, he knew that the respondent was a minor. So, because of that, okay, the respondents actually brought an action for declaration because he or she didn't want to get involved with that contract. Okay, that's why he applied for declaration from the court. So, in this case, the agreement is void. Therefore, it was not binding on the respondent, meaning that the respondent will not be liable for the contract. Okay, there are 5 exceptions under this, okay, because generally minors do not have any capacity. Okay, remember, the general rule is that minor cannot enter into contract, but there are exceptions. These are 5 exceptions in which minor is liable, okay, in case he is entering a contract under these 5 exceptions, therefore he is liable, okay, and can be made responsible for any of those contracts, okay, in case if there is any breach, he can be liable. Firstly, contract for necessaries. Secondly, beneficial contracts or contract of apprenticeship. Third, contracts for scholarship. Fourth, contract for insurance. and 5 contracts made under the age of Majority Act 1971. We will go through one by one. For contracts for necessaries, by virtue of Section 69, if a person incapable of entering into a contract is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So, incapable of entering into contract, this one refer to minor. The person who has furnished such supplies, this refer to supplier, whoever supply the things or products or whatever it is, he is actually entitled to be reimbursed if in case the minor is in breach of the contract. So, a minor is bound to a contract if the contract is for his necessities. It is important for you to note on the definition of necessities. What is considered necessities? Okay, any contract that supplies necessities to the minor is binding on him, and he himself is liable to pay for such necessities supplied. So, necessities ni benda-benda asas yang minor boleh berkontrak sepatutnya. Okay, contohnya nak beli alat tulis ke, nak beli buku-buku nota ke. Okay, and also the price must be reasonable as well. Okay, meaning macam let's say for minor, I think bawah 100 would be okay. Alright, we can still consider it macam affordable lah prices. Kalau dah sampai RM1,000, RM2,000 for someone who is still minor and not working some more, it's too much. We will consider it as luxury rather than necessary. Okay, this is some examples of necessities. You can see, okay, maybe food to eat, and then for educational purpose like books, clothes, or maybe some medication. Provided the necessaries must be reasonably suitable, depends on firstly the nature of the goods or services supplied, and then the minor's actual needs, and see the minor's condition of life, and the price must also be reasonable. However, some necessaries, for example clothing, may become luxury if the minor has adequately been supplied with such goods. Okay, for this, such contract is void. Okay, example of case is Nash against In Mind. You can refer to page 42 of your textbook. Okay, in this case, it was held that the clauses supplied to the defendant were not necessary to the defendant's actual requirement because the defendant was sufficiently supplied with suitable and necessary clothes by his father. Therefore, the defendant was not bound to the contract. Because what happened in this case was that at the time when the defendant was a Cambridge student, he was supplied with clothing to the value of $145. Okay, the clothes supplied included 11 fancy waistcoats. This is luxury for someone who is still a student. It is not necessity, you know. Okay, because of this, it was proof that the defendant's father also supplied the defendant with proper clothes. So therefore, the defendant was not bound to the contract. Okay, if let's say, in this case, plaintiff want to claim the money lah, of course, from the clothes. But the court held that the defendant was not bound to the contract. Okay, secondly, beneficial contracts or contracts of apprenticeship. A contract to provide the minor with the means of self-support or beneficial contracts under which he obtains education or training for a trade or professions. The contract is binding on the minor unless the terms of the contract appear to be unfair and reasonable. Beneficial contracts mean a contract is entered that can be beneficial to the kids or to the minor. Okay. Then contracts for scholarship. According to Section 4, subsection A of the Contracts Amendment Act 1976, no scholarship agreement shall be invalidated on the ground that the scholar entering into such agreement is not of the age of majority. So sometimes minor also can enter into contract. Okay, especially like this one, scholarship application. So in this event, the contract will be binding on the minor, even though he is still a minor, okay, because it falls under one of the exception. Next is contracts for insurance. Okay, for anyone who is over the age of 10, he may enter into a contract of insurance. Okay, this is in accordance with the Insurance Act 1963. Revised 1972. However, under the age of 16, he must get a written consent of their parents or guardians, because for someone who is minor and then he is below the age of 16, he must get the written consent, meaning a form, okay, and the parents must actually sign for so that it is formally made that the parents giving permission or consent for the minor to enter into the contract of insurance. And fifth, contracts made under the age of majority Act 1971. According to Section 4, subsection A of the Act, nothing in this Act shall affect the capacity of any person to act in the following manners, namely for marriage, divorce, dower, and adoption. Therefore, promises of marriage by minors or by their parents on their behalf are valid and binding. So, you don't make promise to marry someone, okay, or else you will be binding. Okay, for example, we can see a case of Rajeswari and another against Balakrishnan and others. Refer to page 44 of your textbook. In this case, the party to this action were Sainan Hindus. A marriage agreement was made on behalf of the plaintiff and the defendant by the fathers. Under the agreement, it was agreed that the dowry is 3,000. If there is any breach of the agreement by either party, the penalty is 5,000. Subsequently, the defendant refused to perform the contract. Then the plaintiff brought an action for damages. Okay, dia nak claim ganti rugi against the defendant for the breach of promise of marriage. The defendant pleaded that the contract is not binding because at that time of the contract, the plaintiff was a minor. For this case, it was held that the contract was binding as the contract of marriage entered into by minors are valid. So therefore, in this case, you have to be liable because you have made that promise. Okay, even though the contract was made between the minor, but because this fall under the exception, you breach the promise to marry, then you have to pay the compensation for the other party. Okay, take note that a minor cannot get married if he or she is under age of 18. This is for non-Muslim. And as for Muslim, the man is under the age of 18 or the woman is under the age of 16. Okay, this is because any marriage shall be void if at the date of the marriage either party is underage. Okay, move on to contracts by insane or drunken person. Section 11 of the Contracts Act provides that every person is competent to contract who is of sound mind. Who is sound mind for the purpose of contracting? So, Section 12, subsection 1, okay, provides that if at the time when he makes it, he is capable of understanding and forming a rational judgment as to its effect upon his interests. Okay, this 2 point is important. He's capable of understanding, okay, and forming rational judgment. He can think rationally the effect of the contract he entered, because this will affect his interests. The following persons are considered of unsound mind because they could not understand and think rationally as to the effects of any contract made by them during the situation and conditions. Okay, for the insane, okay, hide those medicines, intoxicated. Okay, kalau tak boleh berfikir secara waras lah, ya. You demam terlampau panas pun you tak boleh fikir secara waras juga. You mabuk pun you tak boleh fikir secara waras juga. Okay, dia tak semestinya gila. Okay, dia waktu you buat kontrak tu, kalau you boleh berfikir secara rasional, it will still considered as a valid contract. So the suggestion is that the contract is void, okay, by virtue of section 10 subsection 1 and also section 11, provided the person must prove that he was of unsound mind at the time of contracting and the other person aware. Okay, we are done with this topic. So thank you.
Take my